Good morning, everyone, and welcome to our final HR Law webinar of this year. I'm Jo Chatterton. I head up the employment team here at Fox Williams. Just before we start, a few admin points. The webinar is going to be recorded and made available to those who've registered but not been able to join us this morning. If you would like a copy to share with your teams, then please do let us know. We'd be happy to share that. We're also very happy to take questions on topics under discussion today. So if you could please put these in the Q&A box rather than the chat function, we'll aim to address those at the end of the session. So in today's webinar, we're going to be taking a look ahead. My colleague Kim is going to highlight some recent employment law changes which have come into play this year but won't come into effect until 2024. But obviously it's important that we know what's coming down the line so we can stay on top of those developments, get prepared, brief our teams, change our policies if we need to, etc. We're also going to touch on some developments from regulators. Now, I know not all of you will be regulated by the same bodies or even regulated at all, but I think it's interesting to understand what's happening in other sectors within the business world, because they will impact us and may demonstrate a sort of trend or pattern of behaviour, but also give us lots of food for thought and ideas about how we might be handling things. So in particular, we're going to be focused on diversity and inclusion, and there's some sort of big changes afoot in the financial services arena. On the theme of diversity and inclusion, Jane is going to be looking at the very important topic of workplace bullying and harassment. Now, there's been much press coverage over the last year about harassment, and it's not sector specific. It covers the complete spectrum of business life, and I'm sure that won't have escaped your notice, and it's certainly been very much a recurring theme in our practice here at Fox Williams. We have been carrying out lots of investigations, supporting our clients to conduct those investigations, as well as disciplinary and grievance processes, and also helping clients to navigate their regulatory obligations at the same time. Now, as we all know, bullying and harassment allegations are very sensitive. They are often very complex. And they raise many grave areas and difficult questions, and they take up a lot of management time. And I think what we can say from recent experience is that the direction of travel is pretty clear. Employees are increasingly aware of their rights. They're increasingly willing to speak up about bad behaviour from colleagues, whether that's happening now or whether it's happened in the past. And they are increasingly willing to progress employment claims if they don't get the redress or feel that their issues are being taken seriously and they're being looked after. So a very important topic that Jane will cover in some detail. So without further ado, I'm going to pass over to Kim, who's going to start the session. Thanks, Kim.
Thanks, Jo. Good morning, everyone. So as Jo mentioned, in my section of today's webinar, I'm going to talk you through some upcoming employment changes to watch out for. So I'm going to start off by talking about 3 new employment acts, which are reflected in the first 3 circles on the next slide. Yeah, perfect. Thank you very much. So I think it's fair to say that we've been talking about the draft legislation for these acts for some time now. So I don't think that they're going to come as any great surprise to you. However, it is important to understand the final content that has made it into the acts and what you need to be thinking about before the law takes effect. On the last 2 circles on the slide are additional areas where we have seen new employment law emerge this year. So I'm going to summarise those later rather than going into detail. I should flag that the timeline for each act taking effect is slightly different, although suffice to say that 2024 is likely to be a busy year, keeping on top of all of the changes. And there is also the prospect of a general election at the end of next year, which has potentially significant implications for employment law, as I'll mention later. Next slide, please. So first of all, starting with the Employment Relations Flexible Working Act. So this act became law in July of this year, but the changes aren't expected to take effect until next summer. So as you'll be aware, this act introduces various changes to the current statutory right to make a flexible working request. So that includes making the right to make a flexible working request a day one right. Now, that isn't mentioned explicitly in the Act, but the supporting regulations are expected to remove the current 26-week service requirement. It also removes the requirement for employees to explain the impact of their request, which they're currently required to do, and it allows employees to make 2 requests in any 12-month period rather than 1. It also reduces the deadline for you to respond to flexible working requests from 3 months down to 2. And another change is that employers must consult on alternatives before rejecting a request. Now, that's simply good employee relations practice and something that I expect that you are already doing when you're considering flexible working requests. However, this is now a requirement for you to consider alternatives that could be accommodated and then discuss those with the employee as to whether that meets their needs. Whilst there are many changes introduced by the Act, there are no changes to the current 8 statutory grounds to reject a request, which will remain in place as they are. Now, whilst the Act may arguably present a greater burden on employers from an administrative perspective, the risk profile has not really changed. So as always, you should continue to give any flexible working request due consideration, as if you fail to consider and deal with a flexible working request appropriately, then you could expose the business to claims. The most common one being a complaint of sex discrimination, since it is more often females who are requesting flexibility to allow for childcare arrangements. Any rejected request should be backed up by the reasons, hard evidence, and should follow consistent practice. Final point to mention on this is that ACAS have revisited their current code of practice on handling requests for flexible working, which will be republished following the current consultation process. So the code of practice doesn't give rise to a standalone claim, but employment tribunals must take it into account when looking at complaints about the statutory regime. Next slide, please. So the next Act I'm going to mention is the Workers' Predictable Terms and Conditions Act. Now, this Act is expected to come into force through regulations sometime in autumn 2024. And what this Act will do is give workers and agency workers the right twice a year to request a predictable work pattern if their work is currently unpredictable. New regulations will set out the full detail of the new right and how that's going to operate in practice, but it's expected that it will be modelled and treated very similarly to the flexible working regime. Applications under this new Act may be rejected on specific statutory grounds in a similar way, but not identically to the current flexible working regime. But employers will only have a 1-month time frame to address these sorts of requests, unlike flexible working, which is currently 3 months and then shortly is going to reduce down to 2. An interesting point to note is that a request under this regime will count towards the 2 flexible working requests that employees are entitled to under the new flexible working regime, and vice versa. There is a current draft ACAS statutory code of practice that is being consulted on, and which sets out the proposed eligibility requirements for this sort of request, which is clear that it won't be a day one right. And ACAS also intends to publish non-statutory guidance on the principles set out in the final code. So in practice, if you have a need for unpredictable working arrangements in your business, then you'll still be able to do that, provided that you can justify why that's the case. You'll of course need to have a process in place for dealing with these sorts of requests under the new regime, and you'll also need to make sure that staff are trained to handle requests appropriately. Next slide, please. So the third Act that I'm going to talk about is the Worker Protection Amendment of Equality Act, which passed into law on the 26th of October, but is not expected to take effect until October of next year. Now, usually we wouldn't spend time noting what hasn't made it into law, but given the publicity surrounding this bill, I think it is useful to do so here. So as originally introduced, as I'm sure that you'll recall, the proposed bill would have amended the Equality Act to make employers liable for the harassment of their employees by third parties. So, for example, customers or clients. And it would also have introduced a new legal duty for employers to take all reasonable steps to prevent the sexual harassment of employees in the course of their employment. So the bill encountered opposition in the House of Lords, and that resulted in two significant amendments being made during the committee stage. So the first was to remove the principle that employers would be liable for the harassment of their employees by third parties. Now, that's good news for employers who were understandably worried about the difficulties of policing the actions of third parties. And the second change was to limit the scope of the new duty to take reasonable steps, so that employers are expected to take reasonable steps to prevent sexual harassment rather than all reasonable steps. A new Equality and Human Rights Commission statutory code of practice is expected to be published alongside the new law, and there'll be no standalone claim for a breach of this duty, but if an employee is successful in bringing a sexual harassment claim under Section 26 of the Equality Act, then the Employment Tribunal will have the power to uplift compensation by up to 25%. Now, that's a very useful tool in an employee's arsenal, given the scope for unlimited compensation and injury to feeling awards in harassment claims. Now, whilst this Act isn't expected to take effect until October 2024, it is advisable to get your ducks in a row now, and an audit of existing policies and processes is a good place to start. So in particular, we would recommend ensuring that your equal opportunities and anti-harassment policies are up to date and widely accessible, keeping a central record of sexual harassment complaints, and better still, all such complaints, whether sexual or not, to allow for analysis, and regularly and thoroughly training your staff in the law and how to effectively deal with incidents and complaints. In terms of what constitutes reasonable steps here, it is very similar to what you would be expected to do to demonstrate the reasonable steps defence that employers can currently argue when faced with discrimination and harassment claims. That's a notoriously high hurdle for employers because it's all reasonable steps, but we think that you stand a good chance of showing compliance with the new duty if you stick to the same approach. Next slide, please. So as I touched upon earlier, there are some other acts that have also come into force this year, and there's recent draft legislation that has been published, which I want to touch upon briefly. So firstly, the Protection from Redundancy, Pregnancy and Family Leave Act. This came into law in July 2023, and implementation is expected to occur in due course through regulations. Now, the current position, as many of you will be aware, is that before making an employee on maternity leave redundant in the UK, employers are obliged to offer them a suitable alternative vacancy where one exists. The employee can still be selected for redundancy, but they essentially get priority over any of their colleagues in the same situation if there's a suitable vacancy and they are able to do that role. So under this Act, the priority right is being extended to those who are pregnant, those on adoption leave or shared parental leave, and those who return from these types of leave in the last X weeks. So X is not yet defined, but in press releases made along the way, I think it's fair to say that X is expected to be 26 weeks. So if you're likely to be considering redundancies, it is best to make sure that managers and relevant staff are aware of this upcoming change, as it would be an easy one for this to slip through the net. We spoke about neonatal care and carers leave in our previous webinar, and so I'm not going to go into either of these in any detail, except to simply flag that the Neonatal Care Act provides for additional rights for parents of children who spend time in neonatal care in the form of neonatal leave. And in respect of the Carers Leave Act, it provides for the right to 1 week's paid leave to care for a dependent who has a long-term care need. My final 2 bullet points on the slide reflect that it has been a busy few weeks for government in respect of employment law changes. So first, we have the draft legislation to amend the Equality Act, which was recently published and seeks to codify certain EU-derived discrimination protections, which would otherwise have disappeared at the end of this year due to Brexit. And the second is the draft Employment Rights Amended Revocation and Transitional Provision Regulations, which were published on the 8th of November. So as drafted under those regulations, they would clarify the working time record keeping requirements, essentially removing the requirement to keep detailed records of all working hours and rest breaks of all staff, provided that the employee keeps adequate records. It would introduce rolled up holiday pay for workers who work irregular hours and part-year workers, and it will also allow for an annual leave accrual method of 12.07% of hours worked for irregular hours and part-year workers. In respect of holiday carryover and calculation of holiday pay, the regulations confirm that the EU case law that established workers should be allowed to carry over annual leave where the worker has been on maternity or family-related leave or sick leave will become law, as will the EU concept of normal remuneration for holiday pay, meaning that it includes any commission or regular overtime. As to TUPE, the government will go ahead with its proposal to change the consultation obligations that apply when a TUPE transfer takes place, so that all small businesses, so that's those with fewer than 50 employees, or larger businesses making small transfers, and that would be a transfer of fewer than 10 employees, will be permitted to consult directly with employees if there are no existing representatives in place. Next slide, please. So I'm going to now briefly touch upon the Labour Party's New Deal for working people. So as you'll have no doubt have seen, Labour have announced that if it wins the next general election, within the first 100 days of entering office, they will bring forward an employment rights bill, which would mean significant reform to employment law. Now, the Green Paper discusses extensive reforms, and we have a selection of the proposals on the slide there. I'm not going to go into any of these in any detail, as of course these are just proposals at this stage. However, a couple of headline points to bring to your attention are the proposal to end certain qualifying periods, so in effect creating day one rights in relation to unfair dismissal, sick pay and parental leave, for example. And also the creation of a single status of worker in place of the current position, where individuals can fall into one of the three categories, being employees, workers or self-employed. And as you'll be aware, each of those three categories has different levels of employment law protection. So the general idea, we are told, is to create fairer working conditions, which in turn Labour will hope will improve productivity, economic opportunity and employee health and well-being. One thing is for certain, if Labour get the opportunity to implement the New Deal for working people, employers will be facing significant changes to the employment law landscape. So it's absolutely one to watch out for. Next slide, please. So finally, I'm going to finish up on two financial services specific changes of importance to employers in the sector, which I think will also be of wider interest. So the first is the removal of the banker's bonus cap, which was officially scrapped on the 31st of October. Now, the bonus cap has been in place for a long time, and it operated in relation to material risk takers to limit the ratio of variable pay to no more than 100% of their fixed pay, or 200% if there is approval from the employer's shareholders. The PRA and FCA published a joint policy statement in September, which removed the cap earlier than previously anticipated and states that the change applies to a firm's performance year from the 31st of October onwards and to future years. Now, of course, the process of adjusting employee remuneration packages is going to take some time to sort out, so firms might choose not to make changes to the current performance year. That said, if changes are made, then there's helpfully no need for firms to resubmit their remuneration policy for the current year if that's already gone to the regulator before the 24th of October. It's worth flagging that it's only the cap that's been removed, so firms are still expected to align their remuneration policies with prudent risk-taking, and the existing tools for managing risk will remain, such as deferral of bonus payments, paying a proportion of bonus in shares rather than in cash, and the ability to reduce or claw back variable remuneration in certain circumstances. In our next edition of our HRLaw article, we will be talking about the removal of the bonus cap and the potential implications of this in more detail, so please do keep an eye out for that. My final point is in respect of the PRA and the FCA's joint consultation paper on diversity and inclusion in the financial services sector, which I'm just going to touch upon briefly. So we're expecting a policy statement to be provided in 2024, which will set out the final regulatory requirements, with the new rules likely to come into force in 2025 if the regulators manage to stay on track. The consultation paper has a significant set of proposals for firms to get to grips with. I think it's fair to say that financial services employers have been waiting for some guidance on how they should tackle their employees' non-financial misconduct to meet regulators' expectations. And the new proposals do integrate guidance on non-financial misconduct into the existing conduct rules, the fitness and propriety assessment, and other aspects of the current regulatory regime. Employers will also be required to report their employee numbers annually, and where there are 251 or more employees, additional obligations are proposed, which include implementing D&I strategies, setting various targets for underrepresented groups, and wide-reaching D&I data collection and reporting obligations. Which leads me neatly onto Jane's section of the webinar about why you need to make addressing workplace harassment a top priority.
So good morning, everybody. It's a pleasure to be giving this webinar. And I'm Jane Mann. I'm one of the employment partners at Fox Williams. And Joe mentioned at the beginning of the webinar that we as a firm have extensive experience of dealing with bullying and harassment cases, very often for the employer, and that's the focus of this webinar. But we also act from time to time for people who have been the victims of bullying and harassment, and that gives us a particular perspective on the effect of this type of behaviour on individuals. I myself have quite a contentious practice, and I'm very often involved in advising on some of these situations when they've landed up in litigation or in a very contentious and difficult state of affairs. So coming at it from that perspective, I'd just like to now let you know the agenda for this morning, which is the next slide, please. And here we go. The theme of the presentation I'm giving is why this should be a top priority for employers and the key risks associated with bullying and harassment in today's world. I'll be looking at what is bullying. I'll be looking at some of the law around protecting employees from harassment, and I will be following on from the points that Kim has made and Joe alluded to around regulators and the arrival on the scene of various regulators who are now considering it part of their remit to, if I can sort of put it this way, police their firms in relation to their approach to managing bullying and harassment on the basis that this is a regulatory issue. And I'll come back to that. And then finally, in this session, we have a 5-step action plan, which is always very popular with an HR practitioner audience, because it does at least enable you to have some hope at the end of a session like this, that there are things you can do in order to mitigate what I will now sort of outline are the key and growing risks in this area, which will probably lead some of you to feel a little bit despairing, but please don't despair. There are things you can do in order to manage the risk of bullying and harassment cases in your organisation. So with that little observation, I will now go into the scary slide. So next slide, please. Here it is. This is the scary bit. This is what can happen when things go really, really badly wrong. And so if we just run through some of the recent incidents and what can go wrong. Obviously, if you're an individual, you can lose your job. And Dominic Raab lost his job, and he had a good job. He was Deputy Prime Minister, Justice Secretary, note the Justice bit, and Lord Chancellor. And he found himself at the wrong end of complaints of bullying. And that was investigated by Adam Tolley KC, reflecting a trend that Joe has mentioned, which is the trend for organisations, in this case, government department, to outsource an investigation into an allegation of bullying. And Adam Tolley KC carried out that investigation and concluded at the end of it that there were some examples of bullying. End result, Dominic loses his job. So that's one really bad outcome of an allegation of bullying for the individual, certainly, and it could be for senior people within your own organisations. The next really bad outcome was Crispin Odey, who you've probably read all about this, particularly in the FT, who covered it extensively, who had perpetrated on the accounts in the FT sexual harassment against young women and women in his organisation. Obviously, I expect that is still subject to lots of investigations and litigation, but recently his firm, Odey Asset Management, has closed 5 months after the first allegation surfaced. Another really bad situation, Russell Brand, where this has tipped into criminal allegations and is now subject, as I believe it, to criminal investigations. And so we're not really able to comment too much on that at the moment while those are investigated and possible outcomes are considered. And McDonald's, which we're coming on to on the next slide, which I think is a very interesting situation from the viewpoint of the employer audience on the webinar, because it highlights some of the powers of the Equality and Human Rights Commission. It's also bang up to date because it featured in Parliament yesterday. McDonald's found themselves at the wrong end of Equality Human Rights Commission enforcement action. There was evidence of sexual harassment in the organisation, and that it was not just 1 or 2 incidents, systemic. And the Equality and Human Rights Commission exercised their statutory powers to enter into a Section 23 agreement in February this year, under which McDonald's agreed to do the things that you can see on the slide. So to adopt a zero-tolerant approach to sexual harassment, to conduct an anonymous survey of their staff, to enhance their policies and procedures to prevent sexual harassment and improve responses, to deliver anti-harassment training, to introduce specific training and materials to help managers identify risk areas, and to support the uptake of policy and training materials by franchisees. That's a key point with McDonald's because many of their operations in the UK are operated by franchisees rather than directly by McDonald's, and to monitor progress towards a safe, respectful and inclusive working environment. Now, these agreements can be entered into as an alternative to the Equality and Human Rights Commission taking enforcement action that they're allowed to take under the Equality Act of 2006. And so presumably McDonald's felt that it was preferable to enter into this agreement rather than face enforcement action, which can include the submission of an unlawful act notice by the Equality and Human Rights Commission with demands for firms to take action to address discrimination, in this case harassment issues within their organisation. The reason it's all back in the news again is because there are continuing complaints into sexual harassment at McDonald's, and the BBC are now investigating them. And the top boss of McDonald's, Alistair Macro, in the United Kingdom, found himself in front of the Business and Trade Select Committee yesterday, being grilled by MPs on exactly what they were doing to ensure that sexual harassment was being stamped out in the organisation. The point being that ever since they entered into the February 23rd agreement with the EHRC, there have been more complaints, 407 worker complaints so far, and it's up to 2 sexual harassment complaints a week. McDonald's are continuing their efforts to try and stamp it out and have set up a confidential hotline and investigation unit, as Alistair explained to the MPs. And so the story rests there, but obviously I'm highlighting here some really serious risks for the organisation in terms of both here EHRC investigation and enforcement action, a BBC probe into it, Parliamentary Select Committee inquiry into it, and unfortunately, despite all of that, it seems as if the problem is persisting. So there's obviously some quite deep cultural issues there that need addressing. So moving on, and this one, just an observation from me. It's not really very scientific, this, but just keeping an eye on the media, it does seem to me that there has been an increase in high value claims. Now, these are the ones on screen that have been reported in the law reports, so we can talk about these with a degree of confidence. But in the media, there does seem to be more cases where people are being, just in the employment tribunals, not the ones that necessarily land up in the law reports, but just high value awards. And I think that represents a significant trend because in the past, say if we go back 15 years or so, maybe further back, the tribunals were quite timid when it came to tribunal awards. And even though they had the ability to make very large awards reflecting the actual losses that people could suffer when they're the victims of discrimination, they tended to shy away from it and were quite nervous about high awards. Whereas I think some of that anxiety and nervousness about making high awards, which can be quite significant so far as employers are concerned, obviously depending upon the size of the employer, I think they're overcoming that nervousness a little bit. And I do think there is a more significant risk these days of high value compensation awards, and certainly in the advice I'm giving employers at the moment, I am risk assessing cases that I'm advising on and considering whether or not a case that we may be looking at any given moment is one that could progress to a tribunal and get a very high value award. And I'm flagging up with employers more regularly than I used to this particular risk, and not to just assume that everything can be settled and that the employee won't take it all the way and they won't have the money or the nerve to do it. And that's a point that I think Jo made in her introduction. So next slide, please, if I may ask for that. So if you haven't already had enough from me to decide that this is a top priority issue, here's a few more reasons for arriving at that conclusion. So the first thing I wanted to put up on the screen was a point that can get a little bit missed when we're talking to an employer audience, which is that one of the reasons why this should be a top priority is that it's actually very harmful to employees. And when you act for an employee who has been subjected to serious sexual harassment or bullying, they can be very, very seriously impacted in terms of their health, their happiness, and their earning ability. And people can break down. So it can be a very significant issue for an individual. And we should never forget that that is what we're really all talking about, is that it's fundamentally wrong to subject someone to that treatment when they go to work. Now, looking at it perhaps more from an employer's organizational perspective, then obviously the drawbacks from an employer's viewpoint of having a pervasive culture or incidents, maybe not pervasive, but some incidents of bullying and harassment within the organization, is that it can have a very negative and oppressive effect on culture. It can be very damaging to morale and engagement. You're at risk of losing valuable employees. It can affect recruitment of employees. And from the viewpoint in particular of those who have to manage these situations internally, HR and other senior management, it can take a lot of time to address incidents and be very disruptive. As I have already highlighted, it can give rise to the most horrendous publicity in certain cases, which can have a significant impact on reputation and revenue in the most extreme cases, some of which I've mentioned. It can also affect the position of senior individuals and the leadership group within the business in terms of their reputation and how they are perceived. And as we've already mentioned, it can damage the regulatory standing and position of the organization. And if that was not enough, there are a few more to come on the next slide. And this is the legal slide, the legal risks of having bullying and harassment in the organization, legal costs associated with advising the organization, its management teams around managing individual grievances and complaints, investigations, managing disciplinary processes, and defending claims if you're not able to resolve things internally at an earlier stage. You're all familiar with data subject access requests, which come in at an early stage when an employee is thinking about bringing litigation against the company. They're supposed to be for the employee to get hold of their personal data and understand how the company is using their personal data. But as we all know, it can be the first sign of litigation trouble. And as we all know, managing a DSAR can be an extremely burdensome and troublesome exercise for a company. The employee, of course, is interested in what personal data is held about them, but is also sniffing around looking for the smoking gun that might help them with their litigation. Employment tribunal claims are obvious risk, and a point to note about harassment and discrimination claims is that the claims can be made against the individual responsible for the harassment, and so you can have a claim against both the company and the perpetrator. There's the risk of victimization claims if someone has alleged discrimination and then is subsequently victimized. And then there's the other sort of bunch of claims that can come along with a harassment claim: unfair dismissal, whistleblowing, personal injury. The big issue around harassment claims, not so much bullying, I'll come back to that, is that they fall within the Equality Act, and therefore it's uncapped compensation awards, injury to failure awards, and there's the scope for the outcomes I've just mentioned from the EHRC when there's a finding against a firm. So those are the legal risks. Now, on to the next topic, please. One thing that always mystifies people when you give advice on this is the fact that there isn't a legal definition of bullying, because we all hear so much about bullying. You would have thought that this would have been one of the fundamental concepts in employment law that was actually defined somewhere. But oh no, it's not. And so that is one of the reasons, not the only reason, why there is such controversy around what is actually bullying in the first place. And this all came to light in the Dominic Raab situation, where Adam Tolley's report said that after he'd carried out an exhaustive investigation, he felt that there were one or two instances of bullying by Dominic Raab, and he lost his job, as I mentioned earlier. But it provoked a lot of media comment about what is the difference between strong leadership and getting people to get the job done properly and deliver and perform, and also take instructions from the boss and not resist the boss, sort of passive aggressive behavior from the subordinates, or what is actually tipping across a line into bullying and unacceptable behavior, which is the subject of disciplinary action, or should be. And there was a lot of comment around it can be difficult to identify the dividing line. I think it's an interesting debate. I think in practice, when someone has been subjected to true bullying and of a classically sort of identifiable type, there's not usually any doubt about it, because the effects on the individual are so serious. But there are other situations where it is debatable. ACAS, which in my opinion is a good organization that can be very useful in various situations in providing sensible guidance, have come out, as you would expect, with sensible guidance on what is bullying. And there it is: offensive, intimidating, malicious or insulting behavior, or an abuse of misuse of power that undermines, humiliates or causes physical or emotional harm. I think that's a good definition. I think we could adopt that in the absence of anything sitting in any form of employment statute. And as I've already said to everybody, the effects on an individual can be profound and affect their health and welfare. And I think sometimes in clear-cut, serious instances of bullying, you can't underestimate the effect on someone of having been sort of subjected to this type of treatment. And the next slide has some examples of bullying. And one of the things that has struck me over the years is that bullying does follow when you've come across it quite a bit in practice and you've heard a lot about it, some fairly sort of consistent patterns of behavior. And here we've got some of them: unfair criticism and spreading misinformation about a colleague, consistently putting a colleague down in meetings, deliberately giving someone a heavier workload, excluding someone from team events, posting humiliating, offensive or threatening comments, photos on social media. And when I've looked at bullying, the thing that has struck me about it is that the individual feels trapped and that they have no escape from the person who is bullying them, because no matter what they do, they will feel they will be put down, criticized, that they feel they can't do anything right. They try and please the bully to no effect, then they rebel to no effect. And the entire situation can make people feel completely desperate. And that's what causes the breakdowns and the health problems. And so in the most sort of serious form, and it does follow quite consistent patterns, actually, in my experience. Having said that, there can be extremely serious one-off incidents, but in my experience, it's generally a pattern of behavior. And it can occur in various different forms: face-to-face, social media, emails or calls. It can take place in work events outside of the workplace, and it can be upward. You can have subordinates undermining managers who can feel bullied, by subordinates, particularly if they all gang up together against a manager. And we've had a few cases like that in the office over the years. And there are sometimes situations where someone who feels that they're a very decisive, firm leader can, without really intending to do so, actually engage in conduct which objectively viewed is bullying or harassment. So that's bullying and how it manifests itself. Next thing on our agenda is harassment. The Equality Act, which does have a definition of harassment, and here it is. I think we can almost recite this in our sleep. Unwanted conduct which has the purpose or effect of violating another person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And where it has a sexual nature, it's sort of sexual harassment. And it can manifest itself by someone who's had advances made to them, rejects them, and then finds that they're no longer promoted, advanced within the organisation, or even possibly dismissed. That's very commonly how harassment cases present. There can still be, next slide, incidents of bullying harassment which occur. Hang on, I've missed a slide. I'm so sorry. Kim, I've missed one. Just back to this, protection from harassment. The employer can be liable, and Kim touched on this because the law is changing on this. At the moment, the employer can give a defence that it's taken all reasonable steps to prevent harassment, and the law coming in will actually potentially be a little bit more favourable in relation to harassment cases, because it will be that the employer has taken reasonable steps to prevent harassment, not all reasonable steps. So I'm not quite sure how that's going to work out, the sort of distinction between the two duties on employers. Practical point for everybody, the EHRC, the Equality and Human Rights Commission, have useful guidance on the prevention of sexual harassment, which I think is probably quite a good idea for those of you who are responsible for drafting policies and procedures to take a look at their guidance, which is very useful. I was going to make a point a moment ago about harassment and bullying capable of taking place outside of work in a social environment that is connected with work. And I think I'll just make that point and now focus on the final topic of my presentation relating to regulators, which has been trailed before. Now, the Solicitors Regulatory Authority have recently come out with a change to our rules, and they have inserted into Section 1 of our Code of Conduct a new requirement that we treat colleagues fairly and with respect, that we don't bully or harass them or discriminate unfairly against them, and that if you are a manager, you challenge behaviour that does not meet the standard. And so what the SRA have done is they've made bullying or harassment by an individual solicitor and the firm's response to it a regulatory issue. And I think we can all agree that it's unacceptable to bully or harass a colleague at the workplace, and that should very much apply to solicitors who are held to high standards. But it is a quite significant development that our regulator may get involved and discipline us for that. And a key point here is that the managers within solicitors' firms are now required as a regulatory matter to challenge behaviour. So if they see someone else bullying or harassing a colleague, they have to do something about it. And they could face regulatory action for not taking steps themselves to deal with it. And that is something that is provoking quite a lot of debate and discussion within the solicitors' profession. Firms themselves can also be in difficulty if they don't take steps to ensure that bullying and harassment is stamped out in their organisation, and they can find themselves subject to regulatory action as well. And that has led to the solicitors' firms circulating around themselves and attending lots of presentations around all the steps the law firms should be taking to ensure that harassment and bullying is not tolerated within their organisations, all the sort of things that you would expect in terms of training and policies and so on. So that's the solicitors regulator. Now, moving on now to something you've had trailed before in the slides, FCA and the PRA, Kim has mentioned this. It's the long-awaited publication of the recent consultation document from both the Financial Conduct Authority and the Prudential Regulatory Authority on diversity and inclusion and their proposed approach to non-financial misconduct. Now, this is out for consultation at the moment, and there are a lot of representations going in on this because it's a significant development for financial firms. But the bit that I wanted to sort of pick up on now is the bit that relates to non-financial misconduct and bullying and harassment, rather than the other things in these consultation documents, which are mainly to do with firms promoting diversity and inclusion. And so, like with the Solicitors Regulatory Authority, committing acts of bullying and harassment within your workplace, if you work for a financial services firm, now potentially involve you in a regulatory breach. And if the consultation proceeds as we expect into new regulation, then it will potentially be, a breach of the conduct rules, or potentially, depending upon the seriousness, for an individual to commit an act of bullying or harassment within a financial firm. And obviously there's going to be lots of debate about what is sufficiently serious misconduct to amount to a breach of a conduct rule. And so that is a whole new area of debate and difficulty potentially for individuals and firms. Conduct in private and personal life does not generally engage the conduct rules, but it can be something that is taken into account in a financial firm or a regulator deciding whether someone is fit and proper to hold a senior role within a financial firm. And it can go to whether or not the person lacks, wait for this, moral soundness, rectitude, and adherence to an ethical code. So in financial firms, the practical effect is that HR, compliance, and legal will need to work together very closely to address non-financial misconduct, and it will have all manner of implications. It already does in terms of the firms making sure that they follow a fair process to determine whether someone is guilty of bullying and harassment, whether they are guilty of conduct rule breaches, whether they are still fit and proper to work in financial firms, and whether or not the behaviour needs to be reported on a future regulatory reference. It can also have an impact on the firm's own regulatory standing if a tribunal finds that the firm is guilty of discriminatory practices. And a practical consequence of that thought is that all the solicitors responding to the consultation are busy pointing out to the regulators that if you have a situation where a firm can be found to be guilty of a regulatory breach, if there's a tribunal ruling against them for discrimination or harassment, then the tendency will be for all the firms to settle the cases rather than run the risk of having discrimination rulings against them that could impact their regulatory status. So I think that is nearing the end of my presentation. We go to the final slide. The steps that you need to take in order to ensure that you don't land up with some of the really bad outcomes. And here we go. Ensure your anti-harassment and bullying policies are fit for purpose and effective. Carry out lots of employee surveys and exit interviews and one-to-ones to make sure that you have your finger on the pulse and know what's going on and can work out if there are any problems in the organisation. Use your common sense, risk assess the workplace and make sure that you work out where there are likely to be problems and take measures to try and head off trouble. In my experience, harassment cases tend to arise in social settings outside of work, but connected with work, and maybe guidance in these types of settings. Lots of training, that's the usual advice from lawyers about how to ensure everybody knows what sexual harassment is and how to deal with it. And final point, take action quickly and to deal with matters swiftly, promptly and fairly, following the ACAS code and your own internal policies and legal guidance. So just the quick sort of 5-step action plan, and that's it from me. I've allowed 10 minutes for questions.
Thank you very much, Jane, and also to Kim as well. And I hope, as we said, even if you're not regulated by the two regulators that Jane's mentioned, we can see a sort of similar pattern of approach in, for example, the ICAEW as well. So I think it's definitely it's good to know what other regulators and other business sectors are doing, because I think that also feeds into the general standards expected by employment tribunals, but also your staff. So I think looking at the Q&A box, we haven't got any questions. So if you do have a question, please do pop it in now, because we'd be very happy to answer it. Jane, I had a question, if I may, because I know that some businesses are facing allegations of historic sexual harassment. One of the cases that I worked on earlier this year was the CBI investigations, and partly that covered historic allegations as well as more recent ones that were reported in The Guardian. Jane, any thoughts on kind of how we address those?
Well, that's a really huge question, Jo. Maybe we could answer it together, because you were actually involved in looking at all of this for the CBI earlier. Immediate thoughts are, investigating it as a reputational matter, and to do the right thing. The individuals may well be out of time unless the cases involve criminal matters, in which case they won't be out of time, and it will be open to the police to be brought in to investigate the most serious cases of sexual assault, which go way beyond the sort of normal harassment that people experience at work. I think the tribunals can very occasionally open up time limits, but they don't tend to, because the employment law regime works on the basis that employees have to raise their complaints quickly, and if they don't pursue claims, they're time barred. It may be it's more of a sort of reputational issue, that the employer accepts responsibility for what has happened in the past and carries out a thorough investigation, and decides internally that they're going to take whatever action they think is necessary, publicize it, and set out the guidelines for the future as to how they will ensure in the future, a bit like McDonald's did, as to how they're going to try and eradicate harassment and bullying within their organizations. Lots of statements that it's completely unacceptable, and that this is an organization that won't tolerate it. Another observation from me as to something that is changing is the whitewash grievance. I think that is not really on anymore in this area, because I mean, for years on end, when one was acting for individuals who would put in complaints of grievances of quite serious harassment and bullying, and you just get back from the employer's side this sort of bland document that denied it all, apart from a few timing and communication issues where they stuck their hands up and said, oh no, we're sorry about that, but fundamentally we reject the suggestion that XYZ bullied or harassed this individual. I don't actually think employers can get away with that anymore, if when they've looked at it properly, that they've decided that in fact bullying and harassment did occur, and they need to actually have a mechanism within the organization for addressing something that they decide is actually wrong, rather than just pushing away the claimant and the individuals internally who may be sort of bringing grievances. I mean, Jo, do you agree with that? I mean, I do think that's...
I do. I think that's, yeah, I think that's a really important point, Jane, because actually one of the things that in our experience over a number of matters actually causes people to go either outside the organisation to the press or to the regulator, or to be talking to colleagues about the situation, is when they feel that there has been a whitewash over the grievance, or that because they feel that their serious concerns are not being taken seriously and not being addressed adequately. And so I think it demands a different mindset to grievances. I also kind of agree with Jane very much that actually the biggest risk often with historic cases is the reputational risk and all that goes with that, in terms of the sort of your relationships with your employees and of course your clients and suppliers, etc. So that even if legally you might feel there's you're not at risk because because of time limits and what have you, actually many businesses in our experience are taking quite strong action against individuals, because they feel that even if allegations are historic, they don't want to be seen not to have addressed and taken strong action once the concerns have materialized. So it is a very tricky and nuanced area, I think. But we've now got a whole load of questions, so I'm going to go through them. Some of them may need quite extensive answers, but I don't know if anyone, Jane or Kim, do you have a view on whether you think hybrid working has changed the nature of bullying and harassment claims?
I think hybrid working has changed everything at work, actually, in a quite fundamental way. And so it will have changed this as well. The media through which bullying and harassment occurs. I mean, I've had clients complaining about being bullied in appraisal meetings conducted by video. And so that sort of, you lose the human connection. And that, I think, conducting an appraisal, a difficult appraisal via Teams with a vulnerable employee, you think there's a much higher risk there of the employee feeling they've been bullied or harassed and a claim. So I think the short answer is yes, in lots of different ways, and that's just one example.
Yeah, I think what we see an uptick in complaints about things like, because people are working different hours and also it's one-to-one, they're not being observed in the office, that harassment is taking place and perhaps going under the radar until it becomes quite serious. So, for example, people feeling sort of intimidated actually in their home with senior people asking them to put their cameras on when it's sort of after hours, that kind of thing, as well as just sort of, I think the sort of social connection and the sort of psychological safety about calling things out kind of erodes in a hybrid environment if you're dealing with people other than face to face, and not having those interactions where you might call things out immediately or other people around you might call things out to you. So I do think I would agree with Jane. I think it has changed things and presents sort of particular types of risks that we're seeing come to the fore. So we've got, if Stephanie, if Labour get in and their bill goes through and unfair dismissal rights go live from day one, do you expect a lot more employers will hire people on fixed term contracts for 3 to 6 months? Any thoughts on that? Jane or Kim? I don't think it's going to make kind of a hold. I mean, if people have rights from day one, it won't matter whether they're on a fixed term contract or a permanent contract. Even on a fixed term contract, they would be able to assert the claim. So that I think won't make any difference if it's a day one right. You asked about the position in France and Spain. I'm not sure any of us would know that answer, but we will have firms abroad that will be able to. If you did have a particular question about that, then we can put you in touch with some relevant lawyers. We've had a question also about whether if a case has a criminal element, can you report it on behalf of the person reporting it, or must they be the ones to go to the police? I've had some experience dealing with police in investigations, and I mean, you can report yourself as the employer. It doesn't have to be the individual, but you're not under a duty to report. Neither is the individual, save in some sort of very exceptional cases. It's often a very challenging and strategic question whether you should report something to the police and at what stage of an investigation, because in my experience, once the police become involved, they often want you to stop your internal investigation because they will be worried about you questioning anybody who might be a perpetrator of sexual assault, for example, or a witness or a victim, because that might sort of taint the evidence if the case does become a criminal one. So it can sort of tie your hands quite significantly, and then you're in a sort of completely different timetable where you are waiting for the police who don't perhaps work in the same speed as you, etc. So I think if there are concerns about criminal elements to a case, I think it's definitely worth taking advice and just thinking through when is the best time, and actually if you really want to report the case at all, if you don't have to. Obviously, in some cases, as we know from the CBI example, and I can say this because it was in the press, the police sort of became involved because they read about the situation in the press. So it may not be that you or the victim, your employee, calls it out to the press. It may be that the police take it on their own initiative to investigate. And the same also goes for the Equality and Human Rights Commission. They don't need to be tipped off. If they read something in the press, they may come knocking at your door and asking questions. A question about training. When would we have training? At the start of employment? And how do you get employees already in the organisation trained without opening discussions in the workplace? Any thoughts on that, Jane or Kim?
Kim, got any thoughts, or shall I mean,
Yeah, I'm happy to take that one. I mean, I think that of course you could have training on commencement of employment, so that could be something that you have as part of your sort of onboarding procedures when you're onboarding new employees. But I think the law changes, and obviously principles derive out of case law, so I don't think it would necessarily raise suspicions with staff if you're having training sessions with existing staff members. Really, that's something that you ought to be doing, regular training with employees. And I think that staff often find it difficult to deal with these sorts of matters, and so having training and equipping them with what they need to be able to deal with it appropriately is probably going to be well received.
Kim, one on a question on third-party harassment. We've received a claim from an ex-employee informing us of third-party harassment. Nothing was raised at the time. It took place in the summer. Do we need now to investigate this, or would it be the external client who would investigate and update us on steps they've taken? Jane, any thoughts on that?
It's a judgment call, isn't it, as to how you react? And I mean, it's quite difficult to give just a sort of an answer to on those facts, because I think if I were advising on that, I'd actually really want to know quite a lot more detail about who the employee was, what exactly had happened, who the client was, and what the relationship was with the client or the third party, and then make a judgment as to whether or not this was something that now was appropriately investigated and dealt with or not. I mean, Jo, what do you think about that one?
Yeah, I think you're right. It's very sort of dependent on the situation, but I think you have to remember that even though, you know, we don't have the law now coming into play about third-party harassment, you do have duties to ensure you have a safe environment for your employees, and a duty to kind of, you know, maintain their trust and confidence. So I do think that you know, some form of investigation with the individual as a starting point should be considered, so they feel they're being listened to. And then I think it will be, depending on what they say, it may be that you have a conversation with the client. I mean, ultimately, it will be for them to address the issue with their own employee, but you can also consider steps like, for example, you know, asking the client not to, you might not want to work with that person anymore. You might want to not expose your employees to social events and networking events with that particular individual. And that's a very tricky conversation, quite obviously, to have with your client. So you need to be kind of thinking about balancing those priorities. But I think you know, certainly from my experience of advising on these kind of matters, I think employers are perhaps braver at sort of laying down the rules with their clients and saying they're not prepared to tolerate this and not exposing their staff to it in a way that perhaps, you know, years ago, you know, people you would never kind of have this conversation with a client. So we are seeing it a lot more, and that being called out, and actually clients in many cases being grateful that they've been told so that they can address the issue themselves. A very tricky client question here that I think many people are grappling with, about advice offering to employers with regard to the conflict in the Middle East and managing this. I think there's publicity around BBC employees being very upset at work because of having to adopt positions they're uncomfortable with. I don't know, Jane, if you had any thoughts on that. And my own thought would be this is a very, very difficult question to address. I think that, you know, as organisations, if you're not a political organisation and you have many kind of interests within your business, you know, to protect about both your employees, the clients, suppliers, anyone you deal with. And I think that, I mean, certainly in the legal profession, you know, looking to what your kind of regulators are saying in terms of messaging, but the key point here is a balanced approach and not taking sides within your organisation, but providing sort of support for people who are impacted. And of course, that can be anyone within the organisation that's impacted by the situation. So it would need to be sort of tailored, but I think it has to be very even-handed to ensure that you're providing support, things like employee assistance programs, coaching and counselling to help. But it is a very challenging one, and I think that there will inevitably people who will be critical of what you do, but I think you can't, in my view, take sides on this.
I think the BBC one is very specific because it's tied up with the way in which they were reporting the conflict. Yes. And the huge amount of criticism they received for reporting it in a particular way, which is obviously incredibly controversial and political. So if you're working for the BBC, you'll have a very particular set of issues. I think for employers, one thing to watch out for is anti-Semitism and discrimination within the organisation itself, because that is a legal responsibility of the employer. It's not just the employer taking up a position on an issue. It's an employer actually having a legal responsibility to ensure that there is no discrimination within the organisation against people by reason of their nationality, their religion, their racial background. And it's a time of heightened tension. There's an increased risk of, racially abusive comments, racial discrimination, and so on. And I think that's a legal duty on employers, which sort of runs alongside the things that Joe's talking about, just in terms of supporting people who are impacted and upset. I mean, we certainly have people impacted here, and it's obviously of great concern to us that we look after our colleagues who are impacted one way or another.
Also, as we've seen this morning, it may have regulatory ramifications as well, particularly, for example, if you are a law firm. So it's important to be kind of very hyper alert to that in the workplace. I think we've still got time if people are on for questions. I think we've still got 60 people listening in. So what should we do if an allegation is raised and somebody immediately resigns? Should we continue that investigation? Jane, any thoughts on that, or Kim? I'm happy to answer.
It slightly depends on whether or not it's a regulated environment, because if you're in a regulated environment, then and there's a financial services regulated firm, then you may have to put the conclusions that you've arrived at on the regulatory reference. And so therefore, if the individual has resigned mid-investigation, I think that is something that has to be reported. And it may be that the employer, as a matter of practice, wants to carry on the investigation insofar as they can, so that they can actually give an accurate report of what actually happened on the reference, even though from an employment law viewpoint, the situation is now resolved because the individual has removed themselves from their employment. What do you think, Joe, on that one?
Yeah, and I think that perhaps I think it depends on the facts that you've got. That one of the things you will be looking out for is, was it just that person, or kind of what lessons can we learn from this, even though the person has resigned? So it may be that if it's something that has been alleged, it's been going on for a while and impacting lots of people, you may want to continue that investigation to ensure that you've kind of covered all the bases, understand kind of what has happened, the reasons why it's happened, and then take any sort of remedial steps to try to make sure that it doesn't happen again. And so I think that's that's not necessarily a regulatory issue, but it's a sort of a feature of trying to make sure that you stamp out discrimination, harassment within your workplace. Just one last associated question is: can the employee request that they resign if there is a determination that they have harassed someone to protect their reference? Jane, I think that goes to your point. If it's a regulated, not really. No.
I mean, there are, in and outside of a regulated environment, most employers just give very anodyne references, and they don't really say the circumstances in which someone left. It doesn't really alter the fact that they were found guilty of harassment, but other than in sort of regulated environments, it's not actually necessary, I think, to put that on the reference, and you just get this anodyne reference saying X worked here from Y to Z, and the new employer is left wondering what exactly happened.
Brilliant. I think we probably exhausted, I think, all of the questions that we had. I think I've covered them all. And thank you, everyone who has stayed on to listen. It's obviously an area of great interest and a topic of great discussion. Obviously, the Fox Williams team are here to help you if you do have any tricky issues, and we've got lots of experience in dealing with them. As Jane says, both from both perspectives, actually. So we hope that kind of when we're advising employers really kind of adds value to the way they can handle it, because it's not just about the legal claims, etc. So hopefully lots to think about. We look forward to hearing from you if you have any other issues that arise from this, but I hope lots of ideas also for how you can make sure, as far as possible, that you don't allow harassment and bullying to arise in your workplace. And also thanks particularly to Kim for getting us prepared for what we need to know about for the year ahead. So thank you very much for participating, and any feedback, please let us know. Thank you.